All right. Hello, everybody. And thank you for joining. We're just waiting a couple more minutes for everybody to join. And this is typically the awkward part. And for those of you who are already here, welcome. And thank you so much for joining us today. All right, then I would say we'll just start. And thank you so much again for joining us today. I'm super excited that you're all here with us. My name is Susanne. I am the co-founder and CEO of Citruslabs, and I am joined today by Heather Bustos, owner and partner at Bustos Law Group. In terms of content, this webinar is all about regulation on product claims, recent changes that the FTC and FDA made, and how brands can now make product claims under the light of these new regulations and also guidelines, and how clinical trials actually play a role to substantiate your claims. And then we will also leave some time for you, the audience, to ask us some questions. For these questions, please put them in the Q&A field in Zoom, or you can put them also in the chat. Now, before we start, I quickly wanted to introduce Citruslabs. Citruslabs is the fastest growing provider of clinical trials for brands. We work with a lot of brands in the health and wellness industry and cover cosmetics, supplements, superfoods, and devices. And world-class brands such as Ham Nutrition, Say Beauty, Your Super, and A System are our clients. Our mission is to elevate brands with affordable clinical studies to then create research-backed product claims that drive business growth. And typically, our clients see increased website conversions, ad conversions, and retail listings after publishing study results. We conduct studies from start to finish, and typically brands outsource the entire clinical study to us. We customize each study to the brand specific goals, which is typically to make very specific claims, and the data, including the clinical study report and obviously the claims that everyone receives at the end, is owned by you, the brand. And typically, our studies involve questionnaires, but they can also involve biomarkers like blood work, skin markers, digital markers like weight, blood pressure, sleep, but they can also involve before and after photos, for example. And in clinical studies, we believe that there is no one size fits all, which is why we customize each study to our clients' goals. Now, enough about us, enough about Citruslabs. Heather, please tell us a little bit about Bustos Law Group.
Thank you so much, Susanne. I appreciate you putting on this webinar. I think it's going to be amazing, lots of great information. Just by way of introduction, I'm Heather Bustos, the partner of Bustos Law Group. So we specialize, we're an extremely niche law firm. We specialize in FDA compliance. We do some FTC and customs, just those kind of come with the territory, but essentially we help brands in the food, supplement, cosmetic, medical device, and OTC drug industries with compliance. So we do everything from labeling reviews to product registrations. We even help with quality audits. So we kind of do a little bit of everything. We help clients from startup companies all the way through established companies where we sit as trusted advisors on their boards. So we do kind of a little bit of everything regarding FDA compliance. And then we really like to work with companies, like I said, here domestically. So we have clients all over the US, but we also have clients internationally as well that import products into the US. So that's a little bit about Bustos Law Group and what we do.
Awesome, great. And then can you explain why claims are actually important?
Absolutely. So claims, really what this slide is all about is we've got two different perspectives. So when you're starting off as a brand, your first major focus is the consumer perspective. You want to build trust in your brand. You want to get your business growth going, solving your customers' problem and creating your marketing content. So you're usually these brands, as a brand, you want to start off with, okay, what are the things we want to put out in the world about our product, about our service, about our brand. One thing that brands don't take into as much consideration, I'm not saying all, but a lot may not consider the FDA's perspective, which is really important as well. We want these two perspectives to align. So from the FDA's perspective, your claims can affect your product classification. So they can pull your product from a cosmetic into a drug category just by the types of claims that you're making. FDA can also glean, it's really the only way they can glean the intended use of your product. So intended use is what would a consumer think that product is used for? And FDA looks at it from that perspective of a lay consumer. And so your claims are going to explain that intended use to FDA. And that will, like I said, go back into the product classification. A lot of brands may not know that labeling actually has a very broad definition according to FDA. So it's not just your packaging, so the outside of your product packaging, but it includes any brochures, it includes social media, websites, all of that is included under the definition of labeling. So it's really important to consider that as well. And then finally, substantiation. That's what Citruslabs specializes in. But essentially, it's making sure that anything that you're claiming on your product, you actually have some kind of scientific substantiation for those claims. So like I said, the reason I think claims are so important is you want to align these two things. And when they're both in harmony, then there's going to be a lot less risk. So those are some considerations when talking about claims.
Awesome. And we will talk about what to pay attention to also, social media and reviews and testimonials later. But now let's talk about why many of us are actually here today. The recent changes that the FTC and also the FDA announced, and let's start with the FTC. Can you explain a little bit about the recent changes made regarding product claims and also which product categories are actually affected by these changes?
Yes, absolutely. So generally, and for me, this is so exciting. I know it sounds a little nerdy, but it's exciting to me when we have updates. The law moves so slow that when we get updates, it's like we're waiting in the wings to see what's going to come out and what changes are going to be made and updates. And everyone is just trying to scramble to get this information and really understand what the agency is trying to put out. So in this case, the FTC updated a compliance guidance. So it was an advertising guidance that was focused on dietary supplements. It's now called the Health Products Compliance Guidance. It essentially, the goal was to synthesize more than 200 settlements and lawsuits that the FTC brought. And so really what they're trying to do with this guidance is give you an insight into the agency's thinking so that you can kind of understand what fleshes out their regulations. So guidances are non-binding, both in law and in practice. So the question is, why does this matter to me? Well, like I said, it gives you an insight into the agency's thinking. So it's really going to help you understand what their position is on different aspects of the law. So one of the updates too is that this expanded into some other product areas. So it expanded into over-the-counter drugs, homeopathics, health equipment, diagnostic tests, and health-related apps. So FTC is kind of expanding the reach of that guidance into these other areas as well. Again, this is all about advertising and kind of the rules and substantiation, things like that. So the FTC uses a certain standard when it comes to substantiation, and it's competent and reliable scientific evidence. What the heck does that mean? It's an extremely vague standard, but the FTC is trying to clarify in this new guidance that it includes randomized controlled human clinical trials. So they're trying to, up the level of what is considered competent and reliable. And there are cases where, I guide clients and we've had these conversations. Obviously, RCTs are very expensive. So what are some ways to get around it? Well, at this point, the FTC is stating that's what you're going to need. And so it's really important to take that into consideration and plan ahead when you are determining what kind of claims you want to make. Also, another update was FTC stated that key ingredient testing can be sufficient, and that's instead of really the alternative is specific product or formulation testing. So they found that doing testing on a key ingredient, so if you can find studies on an ingredient, an example I can think of is, let's say you have a product for weight loss and your key ingredient is green tea extract, then you want to find this level of studies on that ingredient that show the connection between that ingredient and weight loss. So that's kind of an example of the key ingredient testing. And then finally, they updated on the affirmative obligation to disclose negative information. So the problem with the update is that it was extremely vague. So it's leaving industry with still a question mark, I think, of when you're required to disclose negative information. They used words like if it can cause heart disease. Well, what does can mean? It's such a vague term. And so it's really still leaving that open to interpretation. That's going to depend on how conservative you are as a brand and making that determination yourself in-house. So I think the update, although it was a really great effort, like I said, to synthesize these lawsuits and kind of show you a little insight into the FTC's thought process, it still leaves a lot of questions for industry.
Yeah, I think it's really fascinating that they just, basically looked at 200 lawsuit settlements and then tried to find probably a common denominator here. One thing that I think is very interesting is that either you conduct, basically what I'm hearing here, you can conduct an RCT, but if you don't have the money, ingredient testing can be enough, which is kind of, so basically, if I'm a brand, and let's stick with the green tea, right? And there is a study that was conducted maybe in the 70s or 80s. Would that be still sufficient then?
Yeah, I think, like I said, it's leaving it pretty open when it comes to substantiation at this point. And, again, because the standard is competent and reliable scientific evidence, it's not super clear, right? And I mean, the guidance document, I don't know how many pages that guidance document is on substantiation and what it should look like, but it's just not super clear. And what's funny is they said it synthesized all these settlements and lawsuits, but then when you look at the holdings of some of these cases, they go kind of against what the guidance document said. But then according to FTC, they say they've been consistent in their holdings. So it's kind of up in the air, I think, we're going to need more clarification. That's really what I think is going to need to happen. But this happens a lot with guidance documents. It's the same in the FDA side as well. Sometimes it leaves you with more questions than answers.
Yep, absolutely. And that was already the right keyword. Let's move over to the FDA side of things, and FDA regulates cosmetics, right? And there was this, and it's a mouthful, the Modernization of Cosmetics Regulation Act of 2022, which was passed in December last year.
Yeah.
And what does that mean? What are the changes here?
Yeah, so also known as MOCRA, this was passed on the 29th of December, so just before. It's one of the most major updates to cosmetics regulation since I think they said FDR. Like, it's a really major update. And really the key to this is everything is shifting from kind of vague and voluntary to more specific and mandatory. And so this is a major update. Like I said, everyone in the cosmetics industry, is really trying to catch up with what this is talking about. So I'll go through some of the main points. The first is the mandatory reporting of serious adverse events. This was already mandatory in a lot of other FDA regulated categories. Now it's going to be mandatory for cosmetics as well. So industry is going to have to figure out, okay, what's the system? We don't know if FDA is going to use their current system for adverse event reporting, if they're going to create a new one. We don't even know if they're going to stay under the same branch of FDA or create their own because of such an update in the regulation. It's going to take a lot more manpower from FDA. The second is mandatory manufacturer registration. So this has always been voluntary. And really, when I've ever worked with clients on registration, if they ask me, I tell them it's voluntary. Really, the only time we have submitted registrations is, let's say Amazon requests it or a client requests it, but it's not required. So most brands don't register, and now it's going to be required. So that's going to be a major change. Anyone who's involved in labeling, relabeling, packaging, repacking, you can see all those distributing, holding, they're not going to be required to register. So it's really just like manufacturers, anyone who's making cosmetics. The next is product listing. So that's going to be mandatory, and essentially the name on the label. So when you look at a cosmetics label, if it says distributed by, that company is going to be the one that needs to list their products. If it says manufactured by, then that manufacturer will need to list their products. And the question is, how is this going to interact with the current system, which is the voluntary system? We have to see how they're going to update it in practice as well. Okay, so on the next slide, we're going to talk about safety substantiation. So brands really should have already been doing this, but it's now mandatory. So FDA now, really what it means is FDA now has the power to enforce, a more strong power to enforce. So safety substantiation, we kind of got into that in the last topic, but really that's going to be mandatory now to have that on file for your products. Current good manufacturing practices. So this is essentially a set of standards that applies to, it does say manufacturing, it also applies to storage and holding facilities. It really applies to anyone who comes into contact with that product. There are standards. This is things like temperature controls, sanitation, employee training, and current good manufacturing practices is already the standard in the food industry, in the supplement industry, and basically now they're applying it to cosmetics, where in the past it was just make sure that your product is not adulterated, meaning just make sure that your product, doesn't have sanitation issues, it doesn't have mold, things like that. And they didn't really explain how to accomplish that. Now they're going to have a mandatory set of standards for cosmetics. So that's a major, major, major update. Next is mandatory allergen labeling. So making sure you've got your allergens listed. That's another update. Again, like previously on labeling, really the only things, it was very basic. It was like you need the name of the product, the amount in the product, the ingredients. There were a couple warnings you may have to put in certain cases, but it was basically those three things. And now they're kind of expanding on that with the allergen labeling requirement. And then finally, mandatory recall. You would think that recalls should be mandatory, but that wasn't the case previously. So these are all, like I said, some major updates. There are going to be some exemptions for small businesses with gross sales of less than 1 million. We don't know exactly what those will be. So essentially, to clarify, this is currently a law that gives FDA these powers, but now the FDA actually has to promulgate the regulations. So that's where they kind of spell out what the requirements are and get more specific. And then as we already saw in the last few slides, then they'll release guidances that flesh out the regulations even more. So there's a lot that has to happen before this takes effect, December 29th, 2023. But those are the major updates. And I was telling Susanne before the presentation, I have an attorney I work with that's on the board of the Independent Beauty Association, and they're all, prepping for all of this and getting ready for what's to come down the pipeline. So this is, like I said, a major update for everyone in the industry.
Awesome. And this is very specific. As you mentioned before, this is like really in contrast what I feel to what the FTC released, because here you have action items, and it's great that they have specific language around it. Now let's talk about product claims. So with what we've just learned, how does that all impact product claims on cosmetics and also supplements?
Yeah, so I think really the major takeaway from both of these updates is the substantiation part. So you're really going to have to make sure you have good substantiation moving forward. Whenever an agency spends the time to put out a guidance, and in this case, it was a lot of pages of guidance, when they're putting that much emphasis and they're putting that much manpower behind a guidance, that usually means that they're putting emphasis internally on enforcement. And so if that is the case, then you're going to see heavier enforcement on substantiation. So really the goal is you need to be planning. What are the claims you're going to make? Can I make those claims? And then what do we need to substantiate those claims? I think it's going to be similar. The cosmetic side, really the types of claims you can make. I don't think there's been a major update to that. It's pretty similar, but it's just going to really be on the substantiation side that these updates are really going to apply.
Okay. And, you already mentioned enforcement. What are some of the potential legal consequences for brands not complying with these new regulations and guidelines?
Absolutely. So obviously we've got FTC enforcement, so agencies are going to be enforcing. We've got the FDA warning letters, import alerts, so enforcement on the import side, 483s, which are observations that FDA makes when they come out and inspect facilities. So those are the predictable ones, right? The agencies, the major agencies. But there are some other things to keep in mind. I don't know if anyone on here has heard of NAD. It's the National Advertising Division of the Better Business Bureau. This is not an agency. This is essentially an industry watchdog that looks over product claims and essentially will send you a letter as a brand and say, hey, we saw that you're making XYZ claims. Please provide us with, your substantiation for these claims, or we're going to report it to the FTC. And the FTC loves NAD. They love to get these, updates from NAD on claims being made. So usually brands are going to fall in line, even though, like I said, it's not an agency. They're not an agency. They don't have those kinds of powers. They're essentially a watchdog. So that is, something to definitely be wary of, because they're hand in hand with the FTC. And then also plaintiffs' lawsuits. It's becoming a massive thing. I'm getting more and more from a lot of my clients, these questions about, FDA or FTC have this standard, but lawsuits are now pushing that even further. And the problem is that a lot of what these lawsuits are bringing are questions of fact and questions that really have to go deep into litigation to be answered. So it costs a lot of money for brands. So keeping up to date with the holdings of these lawsuits and things that are coming out is going to be really vital, because that is a legal consequence, and it comes in the form of obviously money that you have to spend on attorneys to defend. So those are some major things that I would consider when it comes to legal consequences.
And can you talk a little bit about, FDA warning letters? This is something that nobody wants to receive. And what do you actually do when you get one?
Yeah, so first off, warning letters, you only get 15 days to respond, so it has to be a really quick turnaround. Um, I really advise you getting someone involved that knows how to respond. There is a strategy on how to respond to warning letters, depending on what the issues are that are stated. So when it comes to product claims, to try to avoid warning letters, you want to make sure that you understand the definition of the product category. So understand the definition of a cosmetic. What does FDA define that as, and do you meet that definition? Do your claims meet that definition? Understanding, like I said, the labeling, so that it expands. It's not just the product packaging, it expands way further than that, into social media, websites, things like that. Making sure that your claims, like I said, are meeting that definition. So, if you have a cosmetic product, make sure that your claims are talking about beautifying. They're talking about the appearance. They're not talking about treating rosacea. They're not talking about treating hyperpigmentation. You want to make sure you're meeting the definition. It has to be about the appearance versus anything under the skin, right? Ensure that you have consistent messaging. So going down the chain from the top all the way down, making sure that you're consistently applying the same rules and standards. So I have on there influencers. We can also talk about affiliates. These are the newer age forms of marketing, but making sure that they understand the guidelines of what can or can't be said about your product, because ultimately they're marketing for you. And so FDA can hold you accountable for what these influencers or affiliates are saying. And then finally, substantiating your claims. So you always want to kind of go in the order of, can I say this claim or not? And then once you determine, okay, perfect, we can say it, it falls under the definition, we've got all those boxes checked, then what do we need to substantiate the claim that we're making? So those are some strategies to avoid warning letters on the product's claim side.
All right. So you said 14 days to respond?
15, yeah. It's extremely, it goes so fast. And depending on how long the warning letter is and what's in there, like if it's a claims thing, sometimes you can just like hurry and be like, just clean the website, like wipe it, right? And just tell FDA, like we'll back away slowly. We decided to remove everything. There are situations where you may have to kind of argue with FDA, but with product claims, it's a little bit easier, but it's also harder to get FDA to close out that warning letter, because according to FDA, like, well, if you could just wipe a website, you can also just throw all those claims back up as soon as, maybe a few months pass. So it's with product claims, yeah, it's a lot harder to close out those warning letters as well.
That makes sense, yeah. Now, the term claims substantiation came up now a couple of times. And let's talk about my favorite topic, clinical trials. And you mentioned that claim substantiation, again, is becoming very, very important now. And can you speak a little bit more about the role of clinical studies in verifying supplement and cosmetic claims?
I mean, really, according to FTC, it's the backbone of substantiation. It is the level of study that you need to have to substantiate your claims. And I think what's happening is FTC is trying to bring, cosmetics and supplements up to the level of drugs almost. They're trying to raise the level of substantiation needed. And this is ultimately, it's going to be a cost thing, right? And brands need to really understand and really focus on what are the most important claims to market the product, in the way that you really want to put out the marketing. And so clinical studies, like I said, it's going to become more important, making sure that you have that on file, that you're ready and prepared if an agency does request it. Because I think that that's going to become a really big focus for the FTC in the coming years.
Yeah, and what you mentioned, FTC is listing RCTs, randomized control studies, as part of the clinical trial that you can run. But as you know, there are many different forms of clinical studies, and typically what we see a lot in skincare is consumer perception studies to substantiate claims. In supplements, we see either single group clinical trials or randomized control studies, simply because
Right.
they are just less expensive, right? And do you think that study design really matters? And apart from the RCT, is there like a best study design to verify product claims?
I think it's all going to depend on the claim being made and the weight of that claim. So, depending on how heavy that claim is going to depend on how much backing you should have. And so I think it's the typical lawyer answer, depends, right? Depends on what you're trying to say, and then you can determine what kind of study you think should be necessary to back up that claim, depending on what it is and how substantial it is.
And how does the FTC or the FDA actually evaluate then the results from clinical trials?
So again, I think it depends on the claims being made, and it's all based on like the weight of the type of claim being made, and then determining what kind of study should be necessary. And we're going to go back to that really vague, competent and reliable scientific evidence standard that they give. It leaves a lot of room for industry to kind of make that determination. And really, because a lot of this is relying on, just being good corporate citizens, right? And making sure that you're keeping it on file, unless the agency comes and checks. Like a lot of brands may not think that it's so necessary, but the documentation part is really, really vital.
And you talked before about, claims also being misleading, that this is like, main cause for these regulations. And how does the FTC or FDA actually determine if a product claim is misleading?
So they're going to look at it from a lay consumer's perspective. They're always, and unfortunately, they really see consumers as extremely ignorant. And so they kind of put them at the really low end, and that's the standard they use. They don't use it, an educated consumer. They use like a lay person, ignorant person as the standard of who's reading that claim, and that's how they make their determination. Obviously there's the substantiation piece as well, but that's really the eyes that they're looking through when they're looking at whether claims are misleading to the public.
Okay, so if I'm a brand and I want to make a claim, I should also put the glasses of a lay consumer and
Absolutely.
don't leave any room for interpretation in a claim.
Yes, and that's always the hard part, right? I was having a conversation with a client yesterday, and I said there's a reason that we say it helps with the appearance of fine lines and wrinkles. Like we say that because it has to fit under the cosmetic guidelines. But I was saying, I imagine the first marketer that heard that probably like vomited in their mouth a little, because they're like, this sounds awful, from a marketing perspective. But unfortunately, you have to kind of meet certain requirements. And I think leaving things open to interpretation can always be a little more risky. As much as it's awful from a marketing perspective to be like extremely clear, this is for everyday stress, or, those types of things. Sometimes it's going to help from a risk perspective, like you said, leaving it open to interpretation.
And leaving things up for interpretation, I think, influencers are a big topic here, right? And
Yeah,
obviously, TikTok, they're huge, huge platforms for brands.
yeah,
You
yeah.
already mentioned it before. Now, how do your regulations impact influencers, and how can they actually promote products now?
Yeah, I mean, I think generally it's really important to understand that these agencies can absolutely regulate social media. They can absolutely regulate what influencers are saying, because those are all forms of marketing. The way that I like to define claims is anything that comes from the brand's mouthpiece. So if it's something that another third party is making a comment about your product and what they think it can do, that's out of your control. But when you're paying an influencer to create a post on your brand, that's absolutely in your control as a brand. And those agencies can take enforcement action if those claims are, misleading or outside of the scope. So, like I said, taking it from a cosmetic to a brand to a drug product. So it's really important to understand that those are absolutely regulated platforms. And with the updates that we talked about with FTC and FDA, again, it's going to go back to substantiation, making sure that you have that before claims are made. So again, it's looking at the entire pipeline from top down in the company. What I've created a lot of the times are protocols, claims protocols that say these are some things you can say, these are some things you can't, to try to keep within a certain um, box. Like what does that box look like when it comes to our product and how we market it? So some do's and don'ts. So I think it's going back to being weary of the substantiation requirements and then making sure you're following through down the pipeline.
And just to be clear, so if I'm a brand, I have a moisturizer, and some random person, posts a video how my moisturizer helped them with their eczema, for example, but I didn't pay them, then this would not fall under this. But if I actually pay somebody to blast it out to their community that my moisturizer helped with eczema, then this would fall under the regulation, correct?
Right, absolutely. And I think, FDA is, they see brands as you're always trying to market yourself. And so they would see that as a marketing opportunity. And so, really it's making sure you're taking really good care when you're doing any kind of marketing to make sure you're still fitting within the regulatory guidelines. And, on another note, and we've talked about this before, if that person posted that video and your brand page, let's say your Facebook brand page, went and commented on it and said, "Oh, this is amazing. I'm so glad it worked for your eczema," then right there you're making a claim, even though it's on their page, and so it can extend that far out,
Okay,
definitely.
that's very interesting. And that actually brings us to the last topic of today, which is testimonials. And you actually told me that the FDA is sometimes skimming reviews and that brands actually get in trouble or even receive warning letters based on reviews. Now, can you explain how brands are on the hook when some customer posts something for, same example, moisturizer, help with my eczema?
Yeah. So yeah, this is a really interesting topic for sure. And again, it's gonna depend. So let's say someone makes a testimonial like on a separate third party page that you don't even know exists.
Mhm.
That's not in your control, and so that's not necessarily going to be regulated. But if it's something that's on your website, so for instance, if you have your website open to where anyone who makes a testimonial, it posts, I would be very careful. That's where I would be very cautious. You should definitely be moderating the testimonials that go up on your pages. Um, when it comes to social media, I've created for brands, like for instance, on their Facebook, we have certain rules of engagement on the page, and they have people that work for them who scan their Facebook and make sure that there's not any crazy testimonials that are being made. It's impossible to catch everything, and I want to stress that the FDA is not going to pull one single thing that you say and spend all their time coming after you with a warning letter. but it's an aggregate. So making sure that you have certain things in place, standards, procedures that tell your team, these are the things that are do's, these are don'ts, making sure that that's a company-wide protocol. That's where, you're able to really rein in a lot of these things. So if you, like I said, if your website right now is just anyone who posts their testimonial, it shows up on the page, I would go in and make sure that those are moderated. Absolutely.
Great. Well, and thank you so much, Heather. All of that was very, very insightful. And as always, I learned a lot from you. And just looking at time, let's see if our audience has some questions. And I can already see a couple of them. Okay. So one of the questions is, are the supplement structure function claims included in this new guidance?
So in the FTC guidance, regardless of the claim that's being made, and so structure function, if anyone is not familiar, so with dietary supplements and food, there is a rumor that with food you can't make structure function claims. That's not true. You can, but you do need to have substantiation. So structure function claims are essentially, there's kind of this dividing line between what's considered a disease claim and what's considered a structure function. So a disease claim is something obvious, like it treats cardiovascular disease, but then there are there is also the ability to make claims that your ingredient or your product can affect the structure or function of the body. So an example that everyone uses is calcium builds strong bones. So it is talking about the structure or function of the body and how calcium can affect that. And that is an allowable claim on supplements, but that is a different question from whether it needs to be substantiated. And the answer is it does need to be substantiated. You can't just make a claim that your product or that ingredient in your product does that certain thing, affects the structure or function of the body without having substantiation. So the guidance does apply to those as well. It's a good question.
And then another person is asking about transition time. And I think in your presentation, Heather, you mentioned that they come in effect this year, right? 1 year after. That was specifically for the good manufacturing practice. And the person also has the question what small brands can now do based on all of these new regulations.
What can small brands do, or what's the difference?
Yeah, exactly.
Yeah, I mean, I think when it comes to the FTC update, substantiation can be costly. So smaller brands are going to have to be a little more cautious of, essentially they're going to have to pick and choose a little bit more on what claims they want to make if the substantiation requirements are a little bit higher. When it comes to the transition on the cosmetic side, we've got a year until, it goes into effect. There's going to be some time that FDA is going to have to take. So whenever a new regulation is promulgated, there's time for comment from industry, and then FDA can take those comments. And sometimes they'll take into consideration some of those comments to, modify. So that all takes a lot of time. Like I said in the beginning, like the law moves very slow. But I think it's really important to keep up to date with what's happening and seeing, what regulations come out. And then again, the guidances will fill in kind of the gaps of what the regulations say, because they're usually written in a very vague manner as well.
And then one question is around clinical studies. How many clinical studies would be considered adequate to substantiate a claim on an ingredient in a product?
I think I have to go back to the same kind of vague standard, and it's, I hate to say it, but it depends on what the claim is stating. It depends on the product. What category of product is it? There's a lot of variables, I think, in that question, and that would probably be better answered maybe off the webinar by either me or Suzanne. To be able to tell you in that case. I think it's very specific to the product type, type of claim being made as to what would be adequate from a study perspective.
And one person is actually interested if they are like specific example claims that will now need this level of new substantiation, or if it's, every claim you make. And I think, you answered that also in your previous question, right?
Yeah, I think, look, substantiation is required for any claim. You have any claim that you're making, about your product or about ingredients in your product. So that's something that people may not be aware of, just because it's well known that roses have antibacterial properties, right? That might be something that's well known. Doesn't mean you can just make that claim. And then once you determine if you can make that claim in the first place, then you determine what kind of substantiation is needed. And it's going to be determined on a case-by-case basis. Absolutely.
And then we also have a lot of questions on testimonials and also what counts as an influencer. So one of the questions is, if you use a testimonial on your website from a consumer, but you're not paying them, can you do that? Probably depends on the content, right?
Well, if it contains claims, so let's say hypothetically you have a supplement and the testimonial from the consumer states, I'm so grateful for your supplement, it cured my allergies, right? That's a drug claim. It's not allowed on supplements. And so regardless of whether it may actually be true to that consumer, regardless of whether it's a consumer that obviously they weren't paid for their opinion, but they just made the comment. If it is something on your website, think about what you're using testimonials for. You're using the opinion of the consumer of how that product worked to then market that product to other people. So ultimately, testimonials are a form of marketing, and they're going to be regulated in that way. So regardless of whether you paid the person or didn't, if you paid them, even more so, but even if you didn't, you still need to follow the regulations depending on, what category your product is in.
And what happens if a company actually provides a referral discount to a consumer? Is this then basically same standard as a paid influencer?
I think that it's going to be, there's the first question of control. Do you have control over what they're saying? If you're paying them or you're giving them a discount, depending, it may be just a very honest opinion that they're giving, but I think ultimately you're still going to have to meet the same standard of, if you're posting that on your website or if you're using that in your marketing material, you have ultimate control over what is going up, and it is going to be a form of marketing. So ask that question to yourself. The only time that I think that, you wouldn't have to worry is if, again, it's someone third party making a TikTok, about what your product did for them, and you have no control over what they said, you're not paying them to do anything, then that's ultimately, how can an agency require you to do anything? It's not really your responsibility. But if it's anything that's within your purview as a brand, that's when I would definitely be making sure I have control over what's being said.
And we talked plenty about, the FDA, FTC looking at consumers as, basically really laymen, don't understand a lot. But what if you are actually, selling to other businesses and, having ads, for example, in industry, trade magazines, is then the same, basically the average consumer, is that still the average consumer, or is there like a different standard?
That's a really good question, because I do have clients who, for instance, sell products only to doctors, to doctors' offices. I imagine the agency would take that into consideration if it's really only, if you can prove that you're only selling to people at that level. But I still think you have to meet the requirements of the definition of what your product is. If it's a supplement, you shouldn't be making claims that it treats or prevents any kind of disease. And this is by direct reference, by inferred reference. It doesn't really matter. I think that regardless, you still have to meet the same standard, regardless of who you're selling to. So do I think that if they're not if it's only sold to doctors, they're going to take into consideration? Possibly. But I still think that you need to look at it from a perspective of, does my claim fall within the definition of what this product is allowed to be? So I think the same answer. I hate to keep saying that, but
It's the same standard, right?
right.
So, again, it's around testimonials on websites. I think this is a
Yeah.
really hot topic. And basically, if a consumer leaves a review that has some vague, claimsy language on the website, is it then the brand's responsibility to take it down?
If it's on your website, you can either take it down, you can modify, add like a ... where there was a claim, if you can still salvage some of it. But yeah, I think ultimately, if it's on your website, you're going to be responsible for what's on there. And you can see, FDA has listed testimonials. They've listed, I think we talked about this on the last webinar. There was a brand who on their Facebook page, they liked a comment made by a consumer, and FDA cited that in the warning letter that the brand liked it. And so by liking the comment, that then becomes a way for them to market their product and say what their product does to other consumers. And so ultimately, I think social media, anything that you have control over as a brand, it's coming from your mouthpiece. So it's going to apply the same standard.
And then one question I think is also very interesting to substantiate claims and have like a robust clinical study. Does in that case, the RCT and other studies, do they have to be published and peer reviewed?
They should be. I think they should be, but I imagine there may be cases, but I do think they should be. And I believe the FTC guidance does specify that when they talk about substantiation. That's a good question, though.
Yeah, I also think it's a very interesting question.
Yeah.
Okay, and then I think this is also relevant for many of the people in the audience. What do brands need to disclose, to the FDA about secret ingredients?
That is a very good question. I actually just got a question from one of my supplement clients recently, asking on their supplement facts panel, they wanted to include proprietary blend, right? And I get it. Everyone has their secret sauce, right? Unfortunately, the FDA does require that you list the ingredients by their common or usual name. And, keeping secret really only applies to flavors, not even colors sometimes. It depends. But yeah, there are a couple cases with like fragrance. You can kind of keep that proprietary. But when it comes to ingredients, the idea is consumers need to know what's in the product, right? They have to understand what's in the product because they may have sensitivities. Allergens are usually listed separately, but regardless, they need to know what's in the product. So there's not really a lot of wiggle room when it comes to that. To the proprietary stuff, unfortunately. You don't have to list the amounts, if that's helpful. You don't have to necessarily list the amounts, but you do have to list what the ingredients are. That's from a supplements standpoint.
And then another question about packaging, which I think is really interesting. If you have the key ingredients on your packaging, can you then include claims about them on there as well, or do you always need to link something in terms of proof so that you can actually make claims? Do you have to link study results if you make claims, or are claims on packaging okay?
So it all depends on the claims being made as to what kind of substantiation you'll need. Again, there are cases where you can do the key ingredient, and you can find studies and keep that on file. I have seen a lot of brands more recently, like in the supplement space, where they've been putting an asterisk next to a claim and then including a link to a study, which I think is cool. I think it's good. It shows transparency to the consumer and to, agencies as well. Um, but if there is a claim being made on the product, it should have substantiation of some kind. You can't just like say anything about your product if there's not, some form of substantiating its truth. So yeah, I do think substantiation is required, but the level is going to depend on the claim.
So for example, if it's a cosmetic, right, and the claim is something around appearance of fine lines, then they put it on packaging and they have on the website, clinical trial subpage, for example, then this would be okay.
Yeah, I think that would be great. I mean, to have it on your website's great. It's not required. You can just have it in-house, but I think obviously from a marketing perspective, to have it on your website is great. That's why a lot of people in the, up until this point, I don't know that the guidance has changed things too much, but I think, studies are used as a form of marketing. It's to show the consumer that the product works the way that we say it does. And it's from an independent source. So it does help from a marketing perspective. But again, from a regulatory perspective, you're not required to have it on a website. You just need to have it, available if an agency does request it.
And then once we have a lot more questions, and I think we have time
I
for
see
more,
that.
unfortunately. But one question that I really think is interesting is, if you're posting before and after photos, are they claims?
Love that. And I actually had this conversation yesterday, so I can speak to it. So we were talking about, this is a cosmetic product, and they asked the question, if we have a before and after, and we're just simply showing the difference between the pictures, we're not making a claim, we're just showing the difference. And I gave an example of a client that does a hair, skin, and nails type of supplement product. And if they wanted to show a before and after of someone with a large bald spot on their head, and then the after is all the hair filled in, regardless of whether you're making a claim or not, like an actual word, using words, the pictures can be interpreted by a layperson as, oh, this helps my hair grow. So if I have, some kind of hair condition where my hair doesn't grow, your product is now going to help my hair growth. Unfortunately, hair growth is a drug claim. It cannot be made on a supplement. So you can say things like, it makes your hair look fuller, or it makes your hair look, more shiny, or things like that. You can talk about appearance if it's let's say it's a cosmetic or a supplement, but you can't make any claims about hair growth. So that before and after picture just became a claim. So yes, there are cases where it can be considered a claim, and that's kind of the intricacy of implied claims. So an example, like if you show a picture, I had a client who had a supplement, they showed a picture of a person coughing, that can create an implied claim that it's now meant to treat cold and cough, meant to treat symptoms of a cold. And so that can be an implied drug claim. So it does extend that far. I know it sounds crazy, but FDA looks at implied claims as well, not just direct claims.
That all makes sense. And it's all like a big, big bubble here. One thing that I want to mention that we likely will not answer today, but I think, Heather, it would be great if we could, create a white paper on this, because I think it's very interesting for everybody. Are there any favorite words or phrases that make both legal and marketing departments happy? And I think we should create a white paper on this. I think that's a great question.
Yeah, I mean, look, we'll go back to the slide about the harmony between the two, right? We want to have harmony between what the FDA thinks our product does and what we're trying to put out there in the world. This just, it makes sense, right? And I think ultimately we can't look at it from the perspective of, oh, I just don't want to get in trouble. Let's look at it from the perspective of, if we want to make our consumers happy, we want to make sure that we're saying things that are truthful. We want to make sure that we're, staying within the guidelines of what we're allowed to say about the product. So I think it's kind of a best practice anyways to make, to do right in the market. I'm not going to say everything from FDA is necessarily fair, or there might be things that I disagree with personally, but I think that there's a lot that your consumers can benefit from, following some of these rules. And ultimately that'll help your bottom line. So I think, like I said, the harmony of the two is really important. Yeah, that would be my best piece of advice.
Great. And thank you. Thank you so much, Heather, for your insights. It was really, really helpful. There are still like so many open questions. Unfortunately,
I know.
regarding time, unfortunately, we can't go into many of them. But we took notes, and we try to answer them, in blog posts, emails that we are sending out. And yeah, I hope that all of you learned something about the new FDA, FTC guidelines and how you can now make claims under these new regulations. And if people want to get in touch with you, Heather, how should they reach out?
Yeah, so you can go to our website. You can schedule a consultation if you want to have a quick talk about what your needs are, or you can also email us at info@bustoslawgroup.com. Those are the two ways you can reach out. You can reach us by phone at 832-592-7851 if you like going by phone as well.
Awesome. And you can reach out to Citruslabs on citruslabs.com, or by sending an email to either hello@citruslabs.com or directly to me, Susanne @citruslabs.com. Please note that my name is spelled SUSANNE @citruslabs.com. And thank you so much, everybody, for attending. Our next webinar will be with our partner Bird Hill on February 16th. And in the next webinar, we will talk about elevating your brand with the right content, and specifically how to bring clinical research and product claims to life. And we'll share best practices for communicating results to your audience. Now, thank you so much, everybody, and see you next time. Bye-bye.
Bye.